excuse me. Good afternoon, everyone. We want to thank you for tuning in again as we continue our Know Your Rights workshop series. My name is Janelle White, and I am the director of the Temp Worker Union Alliance Project, affectionately known as TWUAP. Today, we are here again with our partners from Warehouse Workers for Justice and Raise the Floor Alliance legal team. First, I want to tell you a little bit about TWUAP and what it is that we do. So the Temp Worker Union Alliance Project, TWUAP, serves as a bridge between temp workers and unions. We would like to bridge that gap. We would like to ensure that all workers, direct hires, and temp workers have the opportunity or pathway to direct employment, to have equal pay, and to have benefits as well. So without further ado, let me introduce my colleagues from Warehouse Workers for Justice, Bobby and Abdullahi.
Hi, everyone. My name is Abdullahi. I'm the worker organizer here. I'm here with Bobby.
Hi, everyone. My name is Bobby Fries. I'm the workplace justice organizer here at WWJ.
We are a worker center fighting for good living wage jobs in Illinois warehouse transportation industry, because nothing moves without us. Together, we can move toward a better future for all. And I'd like to pass this on to Bobby.
And before we start, I just want to talk about some of the things that we've been up to. TWUAP, along with WWJ, has partnered with CCDPH to do outreach around vaccine information and to host vaccine events. And I just wanted to give an update on some upcoming vaccine events. Seasonal Community Outreach Service, they're having a weekly event in Markham, Illinois. The dates will be 11/26, 12/3, 12/10, and 12/17. Thinking Beyond Bridgeview Community Center will be having an event November 29th. Chicago Heights Union Evangelistic Church will be having an event November 27th. Blue Island Mission Covenant Church on 11/27, and New Beginnings Baptist Church in Floral Heights on 12/4. Thank you, and I would like to pass it back to Janelle.
Thank you so much, Bobby and Abdullahi, for that information. We definitely want to encourage everybody to take advantage of all of the opportunities mentioned to either get vaccinated if you haven't already received a dose, get your booster shot, and also, if I'm not mistaken, I do believe that the flu shot will be available at those vaccine pods and clinics as well. If you'd like more information about those upcoming vaccine events, please feel free to visit our respective websites at www.4j.org or twuap.org. And without further ado, we would like to reintroduce to some and introduce to others our friend Mark Birhanu, attorney Mark Birhanu from the Raise the Floor Alliance legal team. Take it away, Mark, and thank you again for being here with us today.
Thank you. Thanks for the kind introduction. Yeah, my name is Mark Birhanu. I'm an attorney at the Raise the Floor Alliance Legal Department. I'm here today to present on workplace rights as they relate to COVID-19. Share my screen. I have a nice slideshow for everybody. All right, here we go. Okay, so I want to start off by talking about your rights to organize in the context of COVID-19. So, when your workplace is unsafe, or your bosses are implementing policies or programs that you feel as workers either jeopardize your safety or create a significant risk of the spread of COVID-19, you have a right to stand up together and fight back against your boss. So the big law that we talk about here is the National Labor Relations Act. It's a federal law that protects workers' rights to organize with one another. There's a big misconception that you have to be part of a union for your organizing rights to be protected, but that's not the case. So this law, Section 7, protects the rights of you as employees to engage in concerted activity for the purposes of mutual aid and protection. So what does that mean? Concerted activity means two or more workers coming together or one worker calling on other workers to act. So, for example, here, getting together with your coworkers to present a petition to your boss, that would be an example of concerted activity. So would you as an individual worker posting a sign demanding or encouraging your workers to stand together against the boss. So some caveats here. If the action is to be protected under the law, the concerted activity, it must involve workers discussing work matters. So the further away the subject gets from work, the less likely it is to be protected. So, talking about national elections, if you're a private employee, that's a lot less likely to be protected than talking about, wages, asking your boss for wage increase, asking your boss to implement better COVID-19 mitigation strategies. Those are very closely tied to the workplace and are likely to be protected. However, the law, for the most part, only applies to employees, which does include temp employees, but it does not include supervisors, managers, domestic workers, or independent contractors. Moving on. So how do you file a charge if your rights have been violated? So say, your boss fires you after you stand up with your coworkers to demand better treatment, or they cut your hours after you get together and complain about better wages. In that case, you can file a charge with the National Labor Relations Board Regional Director. The charge must be filed within 6 months of the violation, and the charge can be filed against either party that interferes with your organizing rights. So if you're a temp, that means the client company. If the client company has instructed the temp agency not to send you back to work there because you stood up for better conditions, or the agency itself, you can file charges against both. So I've got some more examples of protected concerted activity here. Discussing work conditions, circulating petitions, talking about joining a union, or talking about getting together with a worker center, and striking. Now, the exception to striking here is that if the demands are purely economic, so if you're only asking for higher wages, then your boss can permanently replace you during a strike. But if you've thrown in other things with your demands, for example, if you have demanded that your boss stop interfering with your attempts to organize, in that situation, then the boss cannot permanently replace you if you go on a strike. So I'm going to get into more explicitly talk about health and safety. But before I do that, are there any questions?
So no questions from the viewers as of yet, but I want to take this time to invite those of you who are watching this live to please leave your questions and comments for Attorney Mark Birhanu in the chat via Facebook Live, and we will make sure that he sees those questions.
Thank you, Janelle. Okay, so getting into the Occupational Health and Safety Act, also known as OSHA. So the federal law is, this is the big health and safety federal law. It is enforced by the Occupational Safety and Health Administration, which is also called OSHA. So they're, the big place that you want to go to if your boss is not respecting health and safety in the workplace. So it's not just COVID. It's, hazardous conditions like chemicals. If the, boss isn't installing guards where you think they should be, you can report those complaints directly to the Occupational Safety and Health Administration. There is an anti-retaliation provision in the law, in the OSHA law, that protects workers from being retaliated against due to raising concerns of health and safety. Now, there's a tight time frame here. So if your boss has cut your hours, fired you, demoted you, etc., because you raised a question to your boss about health and safety conditions, you only have 30 days to file with OSHA. So, there might be situations where you have raised a complaint about health and safety, where you can file with both the National Labor Relations Board or with OSHA. You can file at the same time. So those situations would be when you've gotten together with your coworkers to demand improvements to health and safety conditions. Well, you would both be acting collectively and raising a concern about health and safety. So you could file with both the National Labor Relations Board or with OSHA. Now, getting into more local health and safety protections. So if you are in Chicago, and I'll discuss more explicitly some other Cook County municipalities, you have additional protections as a worker when it comes to COVID-19 and how your employer, certain rights or your employer must respect that have to do with COVID-19. So the Chicago COVID Anti-Retaliation Ordinance essentially protects workers from respecting an order to quarantine. So if the worker is obeying an order to quarantine, due to exposure or having actually contracted the virus, the COVID-19 virus, an order that's been issued by the mayor, the governor, the Department of Public Health, or a healthcare provider, or an order, or if you're taking care of somebody who's been subject to an order, such an order. So, for example, you're taking care of your child who's been ordered to quarantine by their healthcare provider, then the employer cannot retaliate against you. They can't fire you. If they do, the employer, has rendered themselves liable to a charge under the COVID Anti-Retaliation Ordinance, and the worker may file a charge with the Office of Labor Standards. I've got their number down there, or file a lawsuit. You can also get in touch with the Office of Labor Standards by just dialing 311. Importantly, this COVID Anti-Retaliation Ordinance only applies to Chicago workers, meaning workers who their workplace is based in Chicago. So they're performing work in Chicago. Now, the Earned Sick Leave Ordinance provides additional protections for workers with respect to COVID-19. And it applies to workers both in Chicago and workers who work in certain Cook County municipalities, which I will go through in a moment. But you want to know, what does the ordinance do? What does the Earned Sick Leave Ordinance do? It gives you a right to earn sick pay. So that's accrued sick pay. A worker under the ordinance accrues 1 hour of paid sick leave for every 40 hours they work, up to 40 hours of earned sick leave in a year. Now, after 6 months of employment, the employer has to allow you to start taking the earned sick leave. And you can carry up to 20 hours of unused paid sick leave to the next year. Paid sick leave can be used for your own personal illness, for example, COVID-19, or the illness of a close family member. So your child, your spouse gets COVID-19. You can take earned sick leave to take care of them. If you're in Chicago or in certain Cook County municipalities, the employer cannot require you to bring in a doctor's note if you are sick for 3 days or less. So on day 4, they can start asking for a doctor's note to prove the sickness. Now, the municipalities in Cook County that this applies to are Barrington Hills, Berwyn, Cicero, Countryside, Deerfield, Dalton, Evanston, Glencoe, Glenview, Kenilworth, Lincolnwood, McCook, Northbrook, Oak Park, Oakbrook, Phoenix, Skokie, University Park, Western Springs, Wilmette, and Winnetka. However, if you are a worker in Cook County in a municipality that is not listed below, I would encourage you to call your village hall to ask if the Cook County Earned Sick Leave Ordinance applies there, because or municipalities do opt in and opt out of the ordinance with some frequency. So it's possible that at the time of your sickness, the municipality will be covered by the Cook County ordinance.
Mark, sorry to cut you off. Can I just interject here for a second?
Yes, please.
We actually have a viewer question, but it's taking us back a little bit in your presentation to OSHA. So the question states, what can OSHA do about worker complaints? It's a double question. And how long can workers expect to wait to hear back from OSHA? Thank you for that question, Jenya.
Yeah, so what can OSHA do about a worker's complaint? They have a variety of remedies. They can order reinstatement if the worker has been terminated for exercising the rights under 11C. They can fine the employer in order to comply. Oftentimes what they'll do is they'll call the employer and begin their investigation, and then the employer will just simply comply because they're afraid of the phone call. As for how long, I can't say at this time how quick the local office is responding to complaints. In the past, it was fairly frequently. I don't know if that's changed during COVID, but there's also options. I didn't mention this, to make anonymous complaints via the OSHA website or over the phone. But yeah, I can't say how long it is currently taking. But in the past, it's been quite fast. I know earlier in the pandemic, I had a worker who made a complaint and heard back within a week. So yeah, it varies. There is a right to refuse dangerous work under certain circumstances. So, those would be in a situation where danger is clearly imminent. But it's a little difficult to get protection under the clearly imminent standard. With COVID-19, at least under the Trump administration, OSHA was not finding that COVID outbreaks met this, imminent danger threshold. I'm not sure if that's changed during the new administration.
Wow.
But that's a question you could ask. That's a question that you could ask OSHA, or a worker could ask OSHA. It's, what are you viewing COVID-19 as an imminent danger in the workplace?
That's really shocking to hear that COVID-19 wasn't categorized as an imminent danger in the workplace. I certainly think that that's changed, especially given all of the stories and accounts that we've heard from workers. Absolutely. And the unfortunate worker deaths related to COVID-19. So maybe we'll on that and see if we can find out some more information about that for our next installment to the series. But thank you, Mark, for answering that viewer's question.
Of course. So getting back into local ordinances, there are also ordinances there's an ordinance effect in Chicago and in the municipalities that are a party to the Cook County Earned Sick Leave Ordinance, which are listed at the bottom. This additional ordinance protects workers' rights to get vaccinated during work hours if the employer is requiring vaccination. So the employer, first and foremost, can't require you as a worker to get vaccinated outside of work hours if they require vaccination. And two, if they do require you to be vaccinated and your appointment is during your shift, then you must be compensated up to 4 hours per dose. If your employer doesn't require you to be vaccinated, you can use paid sick leave, your accrued paid sick leave to get vaccinated. That law only applies, so the right to use work hours to get vaccinated only applies in Chicago and the municipalities listed at the bottom. So we're getting close to the end now, and I think it'd be a good time to stop to take questions. But how do you report violations of these paid sick leave ordinances? So if you're in Chicago, you can call 311 and they'll provide you with the contact for the Office of Labor Standards. You can also reach the Office of Labor Standards directly. I've got their number here, 312-744-2211. For violation of the Cook County Ordinance, it says Chicago there by mistake, call the Cook County Commission on Human Rights, 312-603-1100. So if you are in one of these municipalities listed at the bottom, Barrington Hills, Berwyn, Evanston, etc., you can call the Cook County Commission on Human Rights to make a report of a violation of your own sick leave rights. And then you have other options. So you can talk to a worker center. You can talk to WWJ or TWUAP or both about ways you can address violations through organizing. Maybe you do a protest, maybe you do a press release and get some media attention. You can also file a lawsuit directly in state court. In some circumstances, you can also file in federal court if there's an underlying violation of federal law. But for the most part, for a Chicago paid sick leave ordinance case or a Cook County sick leave ordinance violation, you're going to file in state court. That's all I have in the matter of a prepared presentation.
Okay.
Do we have any additional questions here?
I mean, I've always got questions, Mark.
I know, that's right.
But thank you for listing WWJ and TWUAP as resources for workers who think they may have a legal violation, a violation of their rights. I would like to take this time to highlight that both WWJ and TWUAP do make referrals. We have partnered with organizations, obviously, such as Raise the Floor Alliance and others. So depending on the nature of what you think might be a violation of your rights, we are happy to do an intake, to hear your story, and if applicable, to refer you to a lawyer who can see if there's any validity and proceed with a case. So again, if you think you might have a case, we invite you to reach out to Warehouse Workers for Justice and or TWUAP. You can do so via our Facebook pages. If you're watching this, you're already connected. You can send us a message. Our respective phone numbers are listed, as well as our websites, which I'll give you again, www.4j.org and TWUAP.org. So Mark, I just want to take a second to go back a little bit to talk about, because I mean, this is still kind of murky. The laws are ever evolving, and there is a lot of uncertainty about what qualifies as paid time off during this pandemic. For example, we spoke with a worker who feels as though he may have been wrongfully terminated because he took time off to care for his sick children who had contracted COVID-19. So in that particular instance, and I know obviously you don't have all the details and all the information, but just based on that little snippet, could there possibly have been a violation of that worker's rights?
So, I can't really speak to this worker's particular situation just because of ethical rules, but I can say that, Chicago and Cook County have in certain Cook County municipalities have in effect an earned sick leave ordinance under which workers may take time to care for a sick family member, regardless of if it is COVID-19 or another illness, so long as they've accrued the proper hours.
Okay, thank you. And then, so if that worker or others, like that worker wanted to, follow the proper avenues to pursue this, they could call the numbers that you listed and go through the city of Chicago, possibly the Attorney General's office, and then again through worker centers like Warehouse Workers for Justice and Temp Worker Union Alliance Project TWUAP, who can directly make referrals to attorneys such as yourself. So
yes, no, that's absolutely right.
Yeah, those of you who are watching, we strongly encourage you to just ask. It doesn't hurt to ask. It's either a yes or a no, but nothing beats a failure but a try, right? So,
right.
we'll try our best to continue to provide resources and information and make referrals when applicable to get you guys justice in your workplace. So Bobby, did you have any questions? You muted.
No, I didn't have any questions. I was looking at my group to see if anybody posted any questions about it. About what's going on.
Okay.
The questions at the moment.
All right, well, if we don't have any other viewer questions, we don't want to hold you hostage here, Mark. As always, we want to thank you for taking out the time to provide your expertise. We appreciate this partnership. We're looking forward to the next installment. Speaking of which, the next installment is going to be held on December 2nd with attorney Ada Sandoval, also from the Raise the Floor Alliance legal team. So if you didn't get a chance to ask your questions today, be sure to tune in on December 2nd. That one will be held in the evening at 5:30 p.m. We're trying to change the times to make sure that everybody has an opportunity to view. And if you're catching the replay of this, you can still leave your questions and comments in the comment section under this video, and we'll try our best to make sure someone from our respective teams gets back to you with an answer or a referral if applicable. So without further ado, we want to thank everyone who was able to join us today and tune in live. We hope you enjoyed the presentation and gained some knowledge and information from it. Thank you to my colleague, Bobby Frierson from Warehouse Workers for Justice. And thank you, as always, to attorney Mark Birhanu from the Raise the Floor Alliance legal team. Again, my name is Janelle White, and I am the director of the Temp Worker Union Alliance Project. We invite you to stay in tune with us. Follow us on social media, on our Facebook pages, subscribe to our newsletters and information on our websites, and be safe, be well. Everyone take care and have a good day.
Thank you. Nice to see everyone.